we're going to do an interactive session now. I think we did a similar thing last year, but it's a slightly smaller number of people. So Tora and I are going to sort of lead a discussion on some key issues affecting the charity sector. We've called it State of the Nation. What I'd like to do, if possible, is just to ask for questions at the end. So please keep a note of them and we'll be happy to answer them. But otherwise, I think we might get a bit distracted and we've got a fair bit to get through. So I'm just going to put that slide up on the screen. And this is really following on from everything that we've been talking about this morning. So we've got this sort of triple threat at the moment of rising demand for services for charities, increased costs and eroding income. And Andrew's already touched on how you might want to think about diversifying your income via fundraising, and that's the whole fundraising journey, isn't it, Andrew? And I think I've had some discussions with people already about particularly legacy programmes. But I think that is really key. It's a really tricky time at the moment for charities. We've got a perfect storm, really, haven't we? It's tricky. We talk to our clients about it all the time. It's challenging, and we do accept that. So I don't think it really matters what size you are, really. I think it doesn't matter if you're a smaller charity or a larger charity. It's financial pressures, operational pressures, it's workforce challenges, recruitment, retention of staff, and it's governance challenges. And then we've got the whole emerging risks. We talk about cyber risk, digitisation, all of those things. So what we're going to hopefully do today is give you some tips to help you perhaps think outside the box, do things differently, perhaps think about diversifying income, changing the way you do things. The good thing, I think, is that when we talk to clients, and this is some statistics actually from sector reports, is that 85% of charities still believe that they have capacity to deliver the required services. So that's really good news, it's really positive. And 60% of charities feel optimistic about fundraising. I don't know if that resonates with fundraisers in the room. Seems quite high to me, but it's good news. And 78% of charities feel they're keeping up with digital changes required to thrive. I suspect that is a snapshot, probably, and most people in the room are nodding. So we have to think about adapting. We have to think about diversifying income. We have to invest in resilience. All of that is really important in order to sustain what we do. So we're going to talk about 5 key issues, and then I'm going to talk about, just summarise a compliance issue, which I think some of you need to be aware of. So we're going to talk about accepting and returning donations. We've talked about donations, but actually it's really important for you to understand what the law is around that. We're going to talk about charity funds, because one way you can improve your income and capital position is to think about releasing funds. We're going to talk about charity trade. I think it's a real opportunity. So that's commercial activity. How do you do it? What does the law say? Collaborative working. So again, it'd be useful to understand how many of you collaborate, and that's the whole collaborative journey right through to mergers. And then charity land. So what could you do with your land? What can you do? How has the law changed? And we're going to do it by way of me doing the boring legal bit, and then we're going to have a case study, and it's going to follow through, and we're going to have a general discussion on it, which will hopefully bring to light some of the issues. So, Tora, do you want to talk to us about this make-believe charity, which is going to form the focus of our discussions?
Yes, make-believe. Unfortunately, I realised after making up the name that it was actually a name that's similar to a school in Loughborough. So I apologise, it has no connection to real life. So the Bright Lights Theatre Trust is a charitable incorporated organisation. It was established in 2015 by Higgs, obviously, therefore it's excellent. And it previously was converted or incorporated from a charitable trust, which had been around for quite some time beforehand. It runs a small local theatre, which provides facilities for local groups to put on performances, as well as small touring groups as well. The object's on providing opportunities within the arts, with an emphasis on young people. Main source of funding to date has been donations and grant funding, but as you all know, and as we've heard, it's increasingly difficult to do that, and a new body of trustees have been appointed. They're very enthusiastic, and they are looking to see what they can do about rejuvenating the financial position of this charity. Let's hope that they don't live to regret that.
So let's think about donations and the capacity, perhaps, for Bright Lights to think about its obligations. So we're going to talk about the law around accepting, refusing, returning donations. So We've already discussed what a donation is. It's a very broad meaning. It's any property or money which is given. It could arise by way of fundraising, it could be a gift in lifetime, it could be legacy, or it could be a grant. We're not going to talk about grant funding in return for services because different rules apply for that. So many of you will operate under contracts which provide grant funding for services. So there's new guidance. If you haven't read it, then you should read it. Charity Commission guidance of March 2024, which sets out the Charity Commission's position. So if you get a donation, the general rule is you should accept and you should keep it. So the question then is whether or not you have a power to return or refuse or return it. Now, if you've got a modern constitution, and I guess probably anything post-2000, but that's very rough and ready, you'll generally have that power in your constitution, but it's always worth checking because you can't return a donation or refuse it if you don't have a power. You may still want to seek Charity Commission consent, even though you don't necessarily need to. And we're going to come on to the circumstances in which you might want to. Now, this is a really big departure from the Charity Commission's previous position, which was if you wanted to refuse or return a donation, you had to get their authority. And that was post the President's Club debacle, which many of you will remember. And there were lots of charities that were caught in the crossfire about that. So the general position is you should accept it and you don't need their authority to refuse or return it. But actually, sometimes you have to refuse it and sometimes you have to return it. And that might be, for example, if there's a legal requirement to do so. And we'll come on to that. And at other times, you may decide to because it's in the best interest of the charity to do so. That's really problematic, and we accept that because there's various factors that you need to weigh up, and we're going to come on and touch on that, as well as reputational issues. So it's logical, isn't it, that you have to refuse or return a donation if you know it's come from illegal sources. So proceeds of crime being one of them, unless it was under an order of the court, with illegal conditions. If you know that your donor doesn't have the mental capacity to donate, that's a really interesting one. I don't know what steps people take to stress test capacity. Or if it can't legally be given to you, that sounds ridiculous, but sometimes people get gifts and actually the donor doesn't own them. So those are the circumstances in which you absolutely must refuse or return it. But there may be circumstances in which, as trustees, you think, do you know what, we really should, or we should at least think about it. And that's if it's for purposes outside of your objects or your charitable purposes, so you can't actually use the donation for the purpose it's being given. If there's likely to be a valid legal claim that arises, for example, if it undermines your independence in any way, so if you're being asked to do something which would undermine that, or there's unacceptable burdens. So the one we always talk about here is if you get gifted a property under a will, but the property is in a state of disrepair, and actually the costs of you making that right would outweigh the benefits, or there's unacceptable private benefits. And we're not going to talk about ex gratia payments, we're not going to talk about failed fundraising appeals because those are subject to different rules. So if you can't legally refuse or return a donation, what do you need to think about? Well, I've put a list on here and we're actually going to stress test that with an example now, but really and truly the first step is, do you have a power to? Check your policy if you have one. If you don't have a policy on accepting and returning donations, you should have one. Check your governing document and make sure you comply with that. It's subject to the usual decision-making principles of trustees. So it would have to be taken in a trustees meeting with all relevant information, best interest trust test. And I'd say take advice if necessary, because actually this is fraught with difficulties. So we're going to now just talk this through with a couple of examples which hopefully bring this to light for you. So going back to our case study, we've got Bright Lights Theatre Trust. So they're told by administrator at a trustees meeting that the charity has been contacted by a family office of a very wealthy individual with a proposal of a very large gift to replace the leaky roof on the theatre. All that this donor wants in exchange is to have the building named Musk HQ. No problems there. Just thinking about that, Tora, what are the first steps that you would recommend that trustees take before they arrive at any decision?
The first point is to go to the trustee donations policy that I'm sure all charities have. And hopefully they do, and if not, it might be something worth thinking about. But to look at the donations policy and to think about making sure that you understand both the asset that's being proposed, and also the identity of the individual involved, your know your donor policy. Then the first step is you ought to be keeping it. That's, as Kirsty said earlier, the basic principle, unless there's certain very strict rules about illegality, and so far as we know, there's nothing there. So once you've worked out that you ought to be keeping it, and it's not illegal, you can then go on to think about whether it's in the best interest of the charity to receive it. And I think there are a few things to think about. There's perhaps the reputational questions about being involved with that particular donor, aside from the naming rights, which you might want to think about whether you can soften that a little bit. Also, you've got a hole in the roof, and presumably some extra cash would be really helpful in that respect. So you also need to think about the benefit to the charity in receiving that donation, because that's a really, really important part. But then also thinking about the burden, and it's about assessing the risk and the burden against the benefit that will come from that. In terms of the naming point, I think maybe get advice about the extent to which that is kind of a commemorative plaque, as opposed to might be advertising, which becomes much more complicated in terms of the kind of tax side of things.
So if the trustees decide they might want to consider taking it, how do they actually go about going through that process of making that decision, and what should they document? Because there is always a risk, isn't there, here, that the Commission could come back and ask to understand how the trustees arrived at that decision.
Well, in a really boring lawyery way, to say make sure that you write it all down. Make sure that you, as trustees, properly document your decisions, making sure that you're taking into account the relevant decisions, like the financial position of the charity and the risks, as opposed to maybe the irrelevant ones, like whether or not you like the cars. About balancing those things off, making sure that they're all recorded effectively, and then also think about formally documenting the arrangements between the donor and the charity to make sure that those things are clear.
Some sort of deed or gift or something which
some flexibility, hopefully, in terms of the use as well, would be really helpful, so that you don't just have to use it on the roof if you manage to spend it all. So lots of bits and pieces to think about, but certainly about formally documenting it all.
So in the information we have, probably the trustees would be right and proper to accept it, and they should probably accept it, and that's what the Charity Commission would expect in that situation. But, you know, what if the funder, God forbid, was caught in a scandal regarding social media posts about the role of the arts and society, and he made some particularly difficult comments about how it should only focus on STEM areas, and especially for boys. So he's making some quite derogatory comments about arts funding, and particularly about gender funding. So in that circumstance, what do you think the trustees should do?
I guess it depends a little bit where you are in that process as to your first step. But if you haven't taken it yet, those are all factors that you take into account when you're working out whether or not to accept. But if you have already taken the money, then it will be about balancing those kind of the changes in the reputational side of things, and about whether your existing donors, how they would feel about that. There's all sorts of different things to balance off into that kind of thing.
Yeah, so if they've accepted it, then again, you were looking at returning it, aren't you?
Whether you've still got it.
Yeah. Yes, because I suppose you may well have spent it by that stage, in which case it's likely to be more difficult.
The balance will change in terms of where it might lie.
Okay, so what we now find is that actually the founder has been named in a Guardian and Times scoop on the use of offshore tax havens, and in particular aggressive tax planning relating to UK assets. HMRC has found that to be illegal. So in that situation, let's say you've accepted the funds, so this has come to light after you've accepted them. We're now in the realms, aren't we, of returning a donation. What do we do now? Because actually this is becoming quite problematic, isn't it, for a number of reasons.
So the first thing is not to spend any more till you know what's happening. Then wouldn't speak to the donor. You've got to make sure that that wouldn't be somebody, you don't tell them about your concerns, but speak to the police. Neil's on speed dial. But yeah, just make sure that that you don't spend any more money, and then you'll have to start thinking, maybe you get some advice from the accountants in terms of expenditure and how that would all be accounted for. And certainly a serious incident report to the Commission, to tell them what the position is. It could be a really early, high-level one. This is in the press. We know we've received funds. We don't know anything more about the funds. Because you've received funds, but you don't know that the funds that you've received were those gained through illegal means. So you're not immediately at that point where you have to return. You do need to be able to investigate. If you find out that they're illegal, then obviously they go back. But I guess if you find out that they're not illegal, you kind of revert back to the decision-making we were talking about earlier, which is about balancing the benefit of taking them against the disadvantage of taking them, and then there's the additional reputational aspects of that. So, how big is the hole in the roof?
Not an easy decision, really. But that just goes to show you that it's lovely to get donations, isn't it? But actually sometimes there's a lot more thought that has to go behind it. And just a reminder, obviously, it's the trustees who the Commission would hold responsible in situations where there's any question about decision-making about whether to accept, refuse or return a donation. And it does happen. I think if we're talking about criminal proceeds, there was a case recently about some Cambridgeshire charities. They got some monies which are proceeds of crime. If it comes subject to a court order, then you're safe. So even though it's the proceeds of crime, you are generally safe. But it is, I think, an area where, I don't know what you think, Andrew, but charities just think, great, we've been given some money, this is fantastic. And I think you do need to stress test that. Okay. So charity funds, this is something that you will talk to your accountants about all the time. I know there's lots of accountants in the room, but this is another way that as charities you can think about actually maximising your impact, because there are ways and means in which you can deal with funds which might help your income position or your capital position. So fund accounting applies to all charities. It doesn't matter about your size, and we generally differentiate between unrestricted funds and restricted funds. And it's the duty of trustees to understand the nature of funds, and if you don't, then talk to your accountants and how you can use them. Now, if you use funds incorrectly, that is a breach of trust. So that's a potential restitution claim against trustees. So it is important, and actually it's an area I think that lots of trustees do struggle with because it's quite difficult conceptually. So this is the general sort of position. As you can see, we love to make things really complicated in the world of charity, don't we? So we talk about funds in that way, and you'll get the slides afterwards. But if we're talking about general funds, we all know, we all understand, you can spend that at the discretion of the trustees, as long as it furthers your purposes, your objects. And actually you can use general funds to supplement your restricted funds. Now, designated funds are slightly different. So designated funds are those which the trustees earmark for a particular project or commitments. And that's an administrative designation. There's no legal authority that sits behind that. And trustees can designate funds and remove designations at any time, and they don't need Charity Commission approval. So it's a really nice way for you to set aside funds from general funds for a particular project. It gives you lots of flexibility. Restricted funds, for the charity lawyers in the room, are basically held on specific trusts, so they're for a specific charitable purpose. And actually that carries the weight of the law. You can only spend restricted funds on the purpose for which they were given, okay, and not for any other purpose. And restricted funds, it can be when a donor gives you money, they can say, we want you to spend it on the roof and nothing else. It can be from a financial appeal. If you're fundraising, we're raising funds to buy a new minibus, that would be a restricted funds. And sometimes grant funders require you to hold monies on a restricted basis. And then we talk about restricted funds as either basically endowments or not. Restricted funds, as I say, you have to spend them on the purpose which they were given within a reasonable period. And then endowment funds, just to make it even more complex, essentially are under trust law assets where you can't spend the capital. So you can only spend the income. And many of you will have permanent endowment funds noted in your accounts. And we talk about expendable permanent endowment funds and true permanent endowment funds, and I'm not going to bore you with that now, but as you can see, it becomes very complicated when you start to talk about endowment funds. So, taking our case study a step further, and just to try and put this into some context for you, so we've got a new trustee who joins the board. And they've looked at the accounts and they've noticed that within the accounts there is the Huntingdonshire and Set Design and Artwork funds. Neither of them have been spent over many, many years. So the trustees say, well, the Huntingdonshire fund is restricted and the Set Design and Artwork fund is designated, and we can't spend either of them. So that's why they're sitting there, we can't touch them. There's also the Judy Dench fund, which is noted as being permanent endowment. So that means you can't spend the capital. So what can the trustees spend, I suppose, is the first question. So if we're talking about the Huntingdonshire funds, it's a restricted fund. What is the first step? Not to say that the accountants won't have got the accounts right, by the way, but you might just want to stress test whether or not it is a true restricted fund. So what's the first step you would take?
So I think, with the first one, it's working out what the Huntingdonshire Fund is for, whether it's properly recorded as it is, and in a box in the back of the theatre you find out that it was from a gift originally given to the charitable trust before it incorporated, and it was given specifically to support performances for theatres from Huntingdonshire, which apparently was a place, and Huntingdonshire no longer exists, so while Huntingdon obviously does. And so the restriction is neither relevant nor helpful. So it's been sitting there, unable to be spent, and the trustees are arguably right not to have been spending it. And so, as it's been given for that particular purpose, the trustees should think about making sure that it's available to them. And what they'll need to do is to go to the Commission for consent to be able to change that. And presumably Huntingdonshire is now part of Cambridgeshire, as I found out. And so that would be the kind of extension that you might be able to suggest to the Commission that would be an appropriate one. You'd need to demonstrate to them why it was in the best interest of the charity to do that.
So in terms of sort of thinking about your pots of money, actually, one of the ways you can ensure that you are more resilient for the future is looking at whether some of these old pots of money, and lots of charities have them, actually could be used in a better way, and the Commission are quite open to that. Yeah. It generally does require legal advice, but I think it's a really useful one. We see charities with huge numbers of restricted funds, and actually there's no value or benefit to them, particularly if that purpose no longer exists. So what about the Set Design and Artwork funds? It's designated, but the trustees, they haven't touched that one either.
No. So again, different box, back of the theatre. You find out that was designated by the trustees some time ago when they were trying to encourage the visuals of these performances, but is no longer relevant for the theatre because of some other facilities that they've got. And so the funding's just been sitting there. Now, it was designated, and as Kirsty explained earlier, that's a decision of the trustees. So it's simply a decision of the trustees to remove that designation. But as with all things, having a properly taken trustee decision to remove that designation and that the resolution, and it seems an especially easy way to improve the cash flow if you're not using the funds. Much better for you to do it. And I would say it would be probably a responsibility of the trustees to make sure that they've got access to all of the funds that they can in order to be able to support beneficiaries now and in the future.
So the Judy Dench Fund, so this was a pot of money given by an anonymous donor. Yeah. She wanted to remain anonymous. She didn't want anyone to know. So this was actually a fund which came from the previous charitable trust. So when the trust incorporated as a CIO, it was transferred and it continued to be held as permanent endowment. So what do we mean by permanent endowment? What does it mean for the charities, and what could the trustees possibly do?
Yeah. So as permanent endowment, that means that there's a restriction on spending the capital. So just the income is available to be spent. And often lots of charities have those and they're really useful and there's not a problem. But it's always worthwhile thinking about the level of the permanent endowment there and whether it's actually at a helpful, whether the pot is big enough to be generating something that's useful, or whether actually having access to the capital, even if you weren't to spend it, was going to be better in the long run. We don't know whether there's a particular purpose restriction on this pot, but there might be, but there's certainly the capital restriction. So if the trustees think that actually it's in the best interest of the charity to try to release that, to be able to give access to the capital, then that again would be a decision that would need to get authorisation from the Charity Commission, and you'd need to be able to demonstrate, again, essentially why it's in their best interests. Now, if the pot is small, there are ways in which you don't need to be able to go to the Charity Commission. It all depends on the level of the fund. Boringly, take advice.
And actually, we've dealt with that very recently for a number of charities where we've had to go to the Commission to release permanent endowment funds, and actually they're much more amenable to it than they ever were in the past. And it doesn't mean you then need to spend the capital, but it just gives you flexibility. And of course, if the permanent endowment is land, then I think there's a whole different conversation to be had there. So just a reminder about that, because it becomes much more complicated. So I guess another way in which charities can think about resilience and maximising income and income diversification is trade. So this is commercial activity, and I suspect a number of you do it in the room. I'm looking around, I'm looking at Mark. But this is, again, this is where the sort of law and tax and accounting comes together, and we often work with accountants on considerations about charity trade. Charities can engage in trading, and they get some really decent tax advantages for the trade that they do. So particularly direct tax. Generally, they don't pay tax in certain circumstances. And what do we mean by trade? Well, it's basically the sale of goods, including property or services. It's not always trade. It becomes quite difficult. So again, it's a question of taking some advice. And it depends on a number of different factors as to whether or not this is trade. But it's relevant, really, because charities get huge advantages over commercial organisations for their activities. And as a result, HMRC quite rightly expects them to follow the law in this regard. And it can have quite adverse tax consequences if you fall foul of it. And it's not straightforward. So you can trade as a charity broadly in three circumstances. So if it's primary purpose trade, if it's ancillary trading, and if it's non-primary purpose trade that doesn't involve significant risk. And the main ones there are the conduct of lotteries, which some of the fundraising teams will do, and trading within the small scale exemption. And of course, you can always trade if you use a trading subsidiary. So I'm just going to touch on this very briefly. The slides will be circulated, but when we talk about primary purpose trade, it means trade which we undertake in furtherance of the objects, so it directly furthers the objects. It includes work where it's mainly carried out by your beneficiaries, for example. So examples, I could list loads, but the provision of educational services by a school in return for course fees, that's trade. But it's primary purpose trade, so you can do that in a charity. Sale of educational goods by a charitable art gallery or museum. The great thing about primary purpose trade, as we all know, is it's exempt from corporation tax or income tax if you're a charitable trust, but only if you apply those profits to the charity or for the purposes of the charity. So that's just important to remember. So ancillary trade is that sort of trade which indirectly furthers your objects. So this is treated as primary purpose trade for both charity law and tax purposes. So the main example that we always think about is where you go to a theatre, you're a member of the audience, and you go and have a drink and food in the restaurant. That is what we would call ancillary trade. It looks and feels like commercial activity, doesn't it? But what we say is it's ancillary to our objects, and therefore it's quite okay for us to do that in a charity and to not have an adverse tax consequence. And then there's non-primary purpose trade, which is the area where I think charities can actually make some strides in terms of income diversification. This is where trustees might want to think about outside of the box, about raising funds from trading, which essentially is distinct from furthering your objects. So you can engage in non-primary purpose trade, but you generally shouldn't do it if there's significant risk. And the profits are not exempt from corporation tax or income tax unless you can argue one of the exemptions, including the small scale exemption. And that's just a summary of what the small scale exemption is. The accountants in the room are much better placed to advise on that than us, but it does allow charities to undertake a small amount of non-primary purpose trade if it falls within this and not pay corporation tax or income tax. So the reason for flagging this really is because if you do non-primary purpose trade, you really need to use a trading subsidiary. In fact, you must do so. And actually, trustees should think about using trading subsidiaries if they want to protect charity assets more generally or ring-fence risk. So actually, lots of our clients will use trading subsidiaries even though the activity undertaken by them is actually primary purpose trade. As you all know, the profits from trading subsidiary are not exempt from corporation tax, but the benefit is that you can gift them up to the charity. You just need to make sure that you've got appropriate documentation in place. One of the questions we often get asked is about funding a trading subsidiary. That is an investment by trustees, so you'd be subject to the usual decision making about whether or not it's an appropriate investment, have you got the relevant powers, etc. So it has to be treated like any other investment, so you need to generate a return, etc. Just a reminder really, actually in some circumstances using a trading subsidiary can be disadvantageous, so you need to think about that because you can sometimes lose charity rate relief, your exemption from SDLT. So I'd say take advice probably from your accountant in the first instance, and then probably some legal advice. So let's just talk about this because obviously bright lights, they need to sort of think outside the box, they need to diversify. They've historically been reliant on grant and corporate sponsors for funding, and they've been struggling to find sufficient funds to develop their projects. So they want to expand what they do, and actually they think this is key to financial sustainability. So they want to go above and beyond just relying on donations, and they want to consider trading. There's various options have been suggested, so we've noted those here. So the first is, well, let's just provide some drama, dance and music lessons for a fee. It's definitely trade. Secondly, let's sell music-related books, equipment for those attending lessons at the theatre. And then thirdly, let's just open a cafe or a bar. So if we think about the first one, so providing drama, dance, music lessons for a fee, what are the things that the trustees need to think about in the first instance?
As you say, it seems automatically to be trading. You're generating funds in return for the provision of services. We have been nicely woolly in our description of what the objects are for this charity. So the first thing will be to check whether the purposes for the objects as set out in the Constitution would cover the provision of these lessons. If the objects are drafted in a narrow way, say just to provide performances, then that's not going to be, it won't be able to be providing these by the charity at all. If that is the case, but they think that actually expanding would be really helpful, then it is possible to amend the objects of the charity. You would need to go to the Commission in order to get consent, but it's certainly worth thinking about. If you think actually looking at your objects, they're not quite doing what you need them to do, then you can look beyond that. But if we get to the point where those things are certainly within the primary purposes of the charity, then it would be primary purpose trading. So from a tax perspective, there shouldn't be any difficulties. I guess the other things to think about is that you're starting a brand new course of activities. They are starting a brand new course of activities. So there will be additional things to think about. You'll have children coming into the theatre in a way that they won't have before. You'll need more employees or volunteers. There'll be safeguarding things to think about, insurance, all of those kinds of things. So funds coming in is brilliant, but there will also be some kind of practical considerations as well, beyond the kind of core finance aspects.
But it's really interesting, isn't it? Because actually the flexibility in terms of amending your objects could be key to getting this to be primary purpose trade, so that you can do it without a tax consequence.
And it doesn't seem that far.
It doesn't seem so far
where we are.
And the Commission again, they're mindful of the need for charities to amend their objects. You can't go from being the charity that provides educational services to being an animal welfare charity, but it is possible if you present a decent argument to them about why you need to. They'll always stress test it, so you generally get quite a lot of pushback. But I think that's a really good starting point, is actually if it's not in our objects, but it looks and feels like it's something we can do, then you could potentially look at that as a first course of action. So the sort of next possibility is selling music books, equipment for those attending lessons. Again, it looks and feels like trade, and actually it seems like a really sensible idea. You've got people, they're already there, aren't they? It's an audience for you. What would you think about in this situation? Because it feels slightly different to what we're set up to do.
I think there's certainly an alignment, isn't there, with the primary purposes, and this is obviously assuming that we've got the lessons in to the primary purpose. But I think there's an alignment, but I wouldn't say that it is the primary purpose. But I think this would fall under the ancillary purpose trading category, and therefore it's fine to be doing it within the charity, unless, of course, there's lots of risk attached to it where you might not want to do it that way. But it doesn't seem to me that there would be. It's not
necessarily particularly risky.
No, I wouldn't have thought so. So it feels, again, something that the charity could be doing in order to generate income and is worth thinking through.
So then they're going to think about opening a cafe or a bar. So this really looks and feels, doesn't it, like commercial activity. It's solely for generating profit. It arguably doesn't have anything to do with the provision of the theatre and its services. So what sort of things would you think about here? Because I think there's a sort of question about what sort of trade it is, and then there's the question about risk.
And about who does it, I guess you think firstly about how broad you want this to be. One of the questions one of the examples that Kirsty gave earlier was about a museum, I think, having a cafe next to it. And if you're in the museum, then that's fine. And that would be ancillary purpose trading. And so that might be applicable here. If it's just for people coming for performances in the evening or coming for lessons and using the cafe, then you could see it being ancillary. But I think one of the things the trustees will need to be thinking about is whether that does enough in terms of the potential for income generation. And they might think, actually, we've got an amazing site. It can be accessed from the outside. It doesn't need to be attached to the theatre itself. This could be something that could be really important and valuable in its own right. And in which case, then they could think about doing it on their own. Or think about it being independent. But then it's certainly not ancillary. It's not connected to the beneficiaries using the theatre, and so then it becomes non-primary purpose trading. If it falls within the small-scale exemption, then I guess the trustees can think about whether it would be something for them to do. But you'd kind of hope that it wouldn't. And it's also quite a big undertaking to take on something like that. Employees, alcohol licences, food preparation licences, all of those sorts of things bring with it additional risk. And so I think then it's worth thinking about, well, actually, we probably don't want to hold this within the charity because we want this to be a thing in its own right. So it should be done by somebody different. And so do you want a trading subsidiary to do it? That would be a really good way of doing it. If you did go down that route, you'd need to think about the relationship between the two. As Kirsty mentioned earlier, they're independent. You need to have the proper formal arrangements in place and proper documentation, covenants in place, and the articles of the trading subsidiary being properly set up for that gift aid of the profits at the end of the year. So that's certainly a possibility, and that might work really well. The alternative would be just to find a third party who might want to run it and then lease that to them. We'll go on later to talk about the way that charities can dispose of land and the restrictions that might come along with that. But that would bring in sort of a regular income from the leasing of that land. There'll be reputational things to think about. You know, who do you want to be next to you within your building? But I think there's quite a lot of scope with that one, but therefore quite a lot of things to be thinking about.
Yeah, and actually I think if you think about your duty as trustees, for those of you who are, it is to maximise your income. That's what the Charity Commission expects of you. So, it's okay to keep doing the same thing and hoping for the same result, but actually I think that this is one of the areas, along with what Andrew's talked about fundraising and legacy income, that trustees should be thinking about, because I think this falls firmly within your duty, is should we be undertaking commercial activity to generate profit, income, return, and how do we do that? And I think to not do that probably, and it won't work for all charities. No. If you're grant making charity, of course not, but anybody else. And the things that I think always worth thinking about is your trading subsidiary. The Commission generally does not like mirror boards, so this is an independent board, potentially with some trustees sitting there, potentially the chief executive of the charity, but it has to be independent of the charity, albeit that the charity is generally the sole member.
It's a funny...
It's really tricky, not to underestimate how tricky it is, the relationship between a charity and its trading subsidiary, and it can be quite complex, but I think this is an opportunity, and hopefully it will resonate with some of you, to maximise income. Okay, so I guess another way is not just to think about income, but is actually to think about, do you know what, can we work with other people? And what does that look like? Because actually collaborative working, it goes to the very heart of resilience of organisations. And I think we're really notoriously bad at it in the charity sector, probably, although we might be getting better. But what do we mean by collaborative working? We just simply mean joint working or partnership working. And it covers a variety of different ways that organisations work together, from very informal networks or alliances all the way through joint delivery or even mergers. And actually we are seeing an increasing number of mergers that we're advising on. And I think it's a sign of the times, really, probably. Collaboration can be for a fixed period of time, or it can be more permanent. But the main sort of basis on which we work collaboratively is that we see there's some mutual benefit to us working together. Ultimately, it benefits our end users. So I think, I don't know, but you may disagree with me, but I think you are either driven to collaborative working positively or negatively. And I think most collaborative working, particularly mergers, is negative, so it becomes as a result of something which happened. But when we talk about collaborative working, I think they're the push factors, the things which drive us to look at this in a positive way, to actually actively seek out ways of working differently, because we believe it will help us be stronger as an organisation and meet our mission. So, you know, we know that there is, you know, duplication in the market, and we want to avoid that. We want to share our expertise or our specialism. We want to become bigger and stronger. So push factors that push people towards collaboration tend to be positive. I think the negative, the pull factors, tend to be where we are dragged into it by external factors. So things like duplication, survival, cost cutting. And I think that tends to be driven by the wrong values. And I guess the point I'm trying to make here is that, again, it's part of your duty as trustees to think about whether you can effectively undertake your mission in a different or better way. So it's not just to keep doing the same thing over and over again. And I think actually boards should be looking at collaboration as part of their ongoing strategic discussions, probably led by the chief executive and senior management team. I've just noted on there the various ways that we come across people working together. You'll know others. At the far end, I suppose, is mergers. So that is the sort of the very formal arrangement. It normally results in two charities coming together. Either, you know, they merge into one or other, or they set up a new entity. Alliances, they're very much informal. And then in the middle is where you might be sharing services or delivering a project. You know, you might have applied for funding together. There's lots of different ways of doing it, and I think probably it's something that we need to think about. Now, usually there's no legal barrier to us working collaboratively, so long as it's in furtherance of our objects. So if the organisation we want to collaborate with does the same thing, same activities, same purposes, there's no reason why you can't do it. It has to be an appropriate use of charitable funds, because inevitably there's going to be a cost to doing this. So is that an appropriate use of funds as benefit versus burden? Private benefit must be incidental. That's the general principle of charity law. And it has to be in the best interest. We keep repeating this, but this is the test that we're all subject to as trustees. It's a best interest test. And all I'd say is you need to document the arrangements. I think each party needs to take independent legal advice. We often get approached, you know, can you act for both parties? No, we can't. We can be the lead lawyers, I suppose, for want of a better word, but you will need independent legal advice. There's a cost to that. There always is, unfortunately. And I think you need to take particular care, and we'll come on to this in the examples, if you want to collaborate with organisations that are not charities. And there's Charity Commission guidance on that, because then it's much more difficult to say furtherance of objects, appropriate use of charitable funds, so community interest companies, etc. So with that in mind, again, we've got this great board of trustees. They're thinking outside the box. They're going to do some trades. They're going to release some funds. And they've now been approached by a local music kick, so a community interest company. So I'm sure you all know they're not charitable. It doesn't have its own premises, and they want to partner with the charity to run a music and arts festival based in the theatre. They're really enthusiastic. They've got loads of great ideas, but they've got little or no experience. The trustees are really keen to support this initiative in principle, but I think they accept there's quite a lot for them to think about. So where would we start? What's the first thing that we should think about before we approach this?
I think, again, it's working out whether it's within your purposes to be able to do it. And assuming that it is, and you're keen, then that's great. You can move on to the next bit. And then I think it would be working out whether it is a good thing for the charity to be doing, and that would be thinking about the benefit that you're bringing to the beneficiaries, and more broadly, whether you want to be going down that kind of expanding those activities. Then thinking about this entity in particular and the kick. It's a community interest company, as Kirsty said. It's not charitable, but it is ring-fenced in a certain sense. It is established for community benefit, but you still need to be thinking about the private benefit aspects of that and whether it would be an appropriate partner to be working with. I think of all non-charitable partners, the kick's a pretty good one to be working with. I don't know what you think. And then I think thinking about how you want to run it. There will be, obviously, you're bringing this thing into your property. So there would be risk involved, there would be insurance considerations, and there'd be the kind of day-to-day practicalities of it. But also documenting between the two parties and agreeing between the two parties, even before you get to the documentation, how it's going to work, who's going to be responsible for what, and what you want it to look like, because it's very much part of your activities will have a reputational attachment to you, and I think you want to be very careful to make sure that you and the kick are working together on what you want to achieve. And then I think thinking about the structure of it, and whether you're happy to do it in an informal way, an arrangement, it's a one-off, you just kind of have some sort of agreement between you as to how you'll do things and what you'll do with any proceeds. Or whether actually you think this is amazing, we want to be doing this really frequently, but we want to set up something new, a new organisation that can really focus on this, because I imagine it would take quite a lot of time. So I think when you have an idea that you want to do it, it's then about thinking about the practicalities of what that means and how you can resource it without undermining the kind of activities that you would otherwise be doing.
I think with collaborative working, there's always a reputational risk, isn't there? And I think in terms of decision-making of trustees, that's an appropriate consideration, isn't it? So doing your due diligence on the organisation that you're going to partner with, because it can potentially put it at risk. But I think that's really valuable. But what if the local music organisation was actually a charity? So it's not a kick. So we don't need to worry about the Commission's guidance on working with non-charities. We haven't got the risk of private benefit, because of course the thing about community interest companies is generally directors can be paid, for example. So what does that change how we approach this?
I think it makes it easier to see that it's an organisation that you can kind of be more aligned with. But again, you need to be thinking about whether they're still the right charity to be engaging with. Even if they're a charity, doesn't mean that they're the right one for this particular project. Doesn't mean that you both think the same thing about the project. So, yeah. And
I think in terms of just how you structure this, just thinking, lawyers are notoriously risk averse, but just thinking, how you get out of these type of arrangements is really important, if it does go wrong. Yeah. So documenting it, I think, is key. It's very easy to do it on an informal basis, but I think as it becomes more formal, you do need to think about that. Okay, so another example, I suppose, is about sharing employees. I don't know if anybody in the room does this. It'd be really interesting to know. But so obviously Bright Lights has a large number of volunteers, like many of you do, but it also has a few employees. There's been recent increases in staff costs. Obviously, employment legislation is changing at a pace, and it's become very difficult. And so trustees feel that they need some form of HR support. So they are considering advertising for a part-time HR manager. During the course of the sort of discussions around this, the chair receives an email from the trustees of 2 other charities who've also been considering appointing somebody to a similar role. And what they've suggested is a shared appointment. So 1 HR manager to cover 3 organisations. So this is collaborative working, and this is what we think of in terms of sharing employees, or sharing space would be equivalent. So what are the benefits, I suppose, of the charity entering into these arrangements? And we're not employment lawyers, so don't ask us any tricky employment questions. But what are the benefits, I suppose, for them?
I think with 3 charities working together with a single employee, assuming all of the charities have ebbs and flows in the way that the work goes, that might actually work quite nicely to be able to spread out the really busy times, and potentially also creating a more interesting role, which might encourage different kind of candidates. But then I guess there are some costs that potentially come with that sharing as well, and some considerations.
And I guess probably in terms of the structure of it, that is, again, we're not employment lawyers, that is quite key, isn't it? Because you've got questions about, who is the employer, where the risk lies, what happens if one charity suddenly decides they don't need that support anymore. So anything else that they should think about, or is that the key things?
I think those are the key things. The management side of things. What happens if something goes wrong? And what happens if the employee has a good relationship with one and not with another? There's all sorts of things to think about. And standing on that, we're not employment lawyers, but get some advice.
But it seems like it's an opportunity to provide some efficiencies of scale and flexibility. And I think you're right, you may well get some better candidates. So again, thinking outside the box, is that a possibility in terms of how you work? So then thinking about the very end of the collaborative working journey. So Bright Lights is approached by Star Stage Foundation about a possible merger. Now, Star Stage provides drama lessons at a low fee to children. It operates from a local community centre. It's hugely popular and very successful, but the poor repair of the community centre means that the council is closing it. And without the favourable rates that they can get from the council, then the operation isn't sustainable. So what they're hoping to do is to find another organisation that they can work with and who can continue their work. And they've approached us to see whether we are interested. So this feels like a merger, doesn't it, potentially? And we mean merger in its very general sense. But what should the trustees think about immediately? What are the first things to think about?
I think the first thing is whether it feels appealing, whether they're even interested in taking on that kind of role, those kind of activities, and how they fit with the activities, the existing activities. And then assuming that they are interested and it's a good opportunity, then you start thinking about the practicalities of whether they can, from a legal perspective. Do the objects allow, assuming that we would be the big fish, swallow the little fish, and we take those things in, are they wide enough? And if they're not wide enough, then maybe we think about making them wide enough. Going back to the point that we were speaking about earlier, about making sure that your objects allow for everything that you want to do, including kind of potential growth. And then I think once you've worked out that you want to do it and that you can do it, then is a process of due diligence. And I'm sure that anybody who's gone through any kind of merger process will have thought about and gone through these things before. And it's about looking at the assets. It's about looking at the funding to the extent that there is any. It's about looking at the employees, any debts, the activities, how you think they'll move in, and considering all of those things and whether it still looks like viable, still looks appealing.
And I think this is a prime example, isn't it, of like the push motivation for merger. This is
for
this
them
is
anyway.
for them. This is sort of desperation, isn't it? This is last resort. And again, I think it's incumbent on all trustees to think about merger in a more positive, proactive way, because generally I think when we get approached, it's very reactive. So again, I think it's incumbent on trustees to do that. So
I think from our side of things as well, even though it would be absolutely a real shame for the other charity not to be able to continue to exist, that doesn't mean that it's on bright lights in order to take it on. It might not be the right thing for it. So even though it would be a real shame for it to go, it's about looking after bright lights and making sure that, and it's the priority in those trustee considerations and the objects.
And I guess a merger is a sort of process that you go through, and it's really quite complicated, and it depends on the organisations that are coming together. But, you know, what would you do initially? Because actually this feels like a great, you decided it's a great opportunity. The trustees have considered the risks and the rewards, but, you know, it's your volunteers for a lot of you. You know, what on earth do you do in terms of first steps? How do you even begin to embark on this merger journey?
I think we would usually suggest that the parties set up working groups so that they're able to work both within the charity itself and then together in order to work out how best to progress through it, to carry out the due diligence, to share information, all of those sorts of things. But because you are sharing information, and it will be confidential information, you need to make sure you've got a confidentiality arrangements in place. As things progress, or maybe even early days, depending on how you structure it, but you might be able to put heads of terms in place. And whilst heads of terms aren't binding, I'm sure you've all come across the term before, they are a sort of a shared understanding or a memorandum of understanding, those kinds of things. If you can have those in place early days, it allows things to develop, and it puts in place sort of guardrails for how the merger will progress, and that can be a really helpful thing to do. So I think once you've got confidentiality arrangements in place, heads of terms in place, and this working party in place, and then the time will come when you need to kind of get some external advice as well about how best to move through in terms of the structuring. But I think that tends to be, charities tend to do that when they've worked out that it is really something that they want to do, and that takes some time before you have to get boring lawyers involved. So you're safe.
Amazing. Okay, so I think the last thing to think about before we come on to the dreaded compliance is charity land, because actually, again, this is a way in which charities can perhaps change what they do, think differently, think outside the box, maximise the return from charity land. It's not always about selling it, but when we talk about land, we mean obviously land owned by or held in trusts for charities, so that includes sort of designated land, buildings on the land, but we also mean rights over land, so easements or rights of way or restrictive covenants. So it's the broadest sense for land. And the sort of law around land and disposal of land is obviously quite complex. So we're not like individuals, we're not like corporates, we can't just dispose of charity land at will. So when we talk about disposing of charity land, we don't just mean by sale, we mean by way of lease. We also mean granting or surrendering leases. We mean granting or releasing rights of way, way leaves, etc. So all of these weird and wonderful property interests. And the things to think about when you're talking about dealing with your land is, I suppose, firstly, do you actually own it? And I know that sounds really silly, but particularly if you've got land and it's unregistered, it's checking whether or not you do own land, what the nature of your title is, etc., what the extent of the land is. It does happen, actually, bizarrely. Charities come to dispose of land and then suddenly find, actually, well, it's not our land and it never has been. Be satisfied that disposal is in the best interests. So that's the same test we've been talking about. Know if you have a power to dispose of it. You generally will. So as a matter of law, there's generally a power to dispose of land. And know when you need charity commission authority, because as I say, the law around disposing of charity land is very different. So there's different requirements broadly for if you're granting a long lease over 7 years or you're selling, as compared to granting a lease for less than 7 years. This is very high level, but this is to flag that the law has changed, so in 2022. So you're still subject to the same test, which is you have to get and consider a report, and it has to be on, for the proposed terms, have to be the best you can obtain. But the change now is that whereas you used to have to get a report from a qualified surveyor, you can now get that from a designated advisor. So that would include, for example, an estate agent. Okay, so they've released it somewhat, but unfortunately they didn't get rid of the restrictions which were proposed in the consultation that trustees should just be allowed to dispose of land at will. They've kept that. So if you can comply with that, then you don't need to get Charity Commission authority. But this individual who is going to give you the report, and the report has to set out certain things which are prescribed in the regulations. They have to actually have experience of valuing the same kind of land in the same area. So it's, you know, if they're used to valuing commercial warehouses and you're asking them to value a school, arguably the Commission is going to say they don't have the requisite experience. It can be a trustee or an officer or an employee. So that is interesting. It means you might not have to go externally. The only thing I'd say is insurance policies generally won't cover negligent advice by your trustee. Not that they're going to give you negligent advice, but if they were to give you negligent advice, your insurance policy generally won't cover it. And if you want to pay them, because you might want to pay them, then take advice, because obviously it would be a trustee benefit. If you're going to grant a lease of less than 7 years, again, it's the same process, but the slight difference in the test here is that the report can be from a person competent to give advice. So it's not a designated advisor. I mean, the question is who's competent in that situation. I mean, I certainly wouldn't be. But you may still want to get a report from an estate agent, for example, which would be equivalent to a designated advisor's reports. But it is interesting to see that they've removed that recommendation. So basically, if you can follow that test, you don't need Charity Commission authority, but you will always need Charity Commission authority to dispose of land, any land. And remember, we're talking about leases, grants of easements, grants of rights of way. If you can't comply with the Charities Act, and sometimes people can't get the report because the land is so particular and nobody has the specialism. We had one genuinely very recently, which was basically mines, and it was really difficult to get anybody who could provide a report on what the value of a mine was, a quarry. If you're disposing of land to a connected person would include trustees, spouses of trustees, it would include to a trading subsidiary, and you're disposing of designated land, so that's land given for a particular purpose. Now, if you're mortgaging charity land again, so you're going to go to get some bank funding, again, similar provisions apply. So, taking that context in terms of what you want to do, going back to our case study. So there's a house and it backs on to the land, which is essentially the theatre. But it was given to Bright Lights by a donor many years ago when it was still an unincorporated trust. So
it was a busy old trust, wasn't it?
Before it became a CIA. I mean, they've got everything, haven't they? So it was given for use, for accommodation for children and young people who attended what was then a residential theatre school. So it's not been used as residential accommodation for decades, and it's actually just become a bit of a store. So there's no benefit for the trustees in keeping the house, and they want to dispose of it. So the only question they've got is that it's noted as designated land in the accounts, and they don't really understand what that means or what that means in terms of the steps they need to take to dispose of this. So I suppose the first point is, how do the trustees deal with it given that it is designated land, and what does that mean?
Yeah. When land is designated, as with all land, there are certain statutory provisions to go through, but when it's designated, it's given for a particular purpose. It can only be used for that purpose, and you can't just sell it and just use the funds for something else. Generally, it is okay to sell it and then use those funds to buy an equivalent, and in those circumstances, you just need to go through the statutory procedures in terms of the reports that Kirsty was talking about earlier. But that's if you're replacing it with the same. So I guess the first question for the trustees would be, well, we're selling it. Is that because we want to buy a replacement for it, or do we not need it anymore? And I think in this case, it's pretty clear that they don't need it anymore. Therefore, they want to be getting rid of that designation. So that means that it's trotting back off to the Charity Commission to basically get their consent either to remove the designation or to be able to use the funds for something else once they have been sold. So it's, again, take advice, but it's more complicated because it's designated land, because you don't have that freedom that you would otherwise be able to in terms of just following through the steps in terms of the reports.
I mean, designated land, you're thinking of like village halls, aren't you? Schools, those type of things. And the other thing to flag really is sometimes property transactions can be driven by a particular time frame. And the Charity Commission is not a swift regulator. So you are not, and I'm just smiling at Paul there, but you're not going to get a response quickly. So, you could wait up to 12 months for consent from the Charity Commission to dispose of designated land, to dispose of land to a trading subsidiary. And that's, genuinely, they are so slow that you need to factor that in.
So I guess one of the things to think about that is that when you're looking through your list of funds, to your restricted funds and your designated funds, and thinking, do they still work? Do we still need them? It's also worth having a look at your designated land and working out whether you are actually still using it for those purposes, whether it would be useful, whether you still have that activity that is associated with it. Because it might be that even if you're not planning to sell it, or because you're not, it's not quite right for that point, you can think about that ahead and sort of do that as sort of the tidying up of the balance sheet.
And I think just a reminder really that if you fail to comply with the Charities Act, and we've only summarised some elements of it there, and you dispose of charity land, then the transaction is essentially void. So it is as if it never happened. You would have to go to the Charity Commission. It becomes very complicated then. So it's always worth remembering, if you're dealing with land, I would probably suggest just take some advice before you do anything. Okay, so we're going to probably try and tie quite a few of the things that we've discussed now together into this last slide. So Bright Lights has been offered the gift of a derelict building. So we're going back to accepting gifts right at the beginning. It used to be a very impressive and significant theatre within the community. So the trustees consider that actually they could redevelop the site. It would be a really interesting project, and they might be eligible for some form of heritage lottery funding or other development funding, or they might be talking to Andrew about a major capital project. So they're minded to accept the gift, but there's a lot of considerations here, aren't there, in terms of what we're thinking about. So going back to the discussions that we had earlier, it's a gift. It's a donation. What should the trustees think about here, given that we're talking about a derelict building?
So again, it's the starting position would be that you accept the gift, but that has to be on a balance of the benefits and the disadvantages. And in this case, it's a derelict building, and you presumably don't have the funding at that point in order to be able to do anything with it. So you're potentially taking a large derelict building onto your balance sheet. And that might not be the best thing to do. So about thinking about that, the acceptance of that, as we were speaking about earlier, kind of in the round, and also thinking about whether, were you to get that gift, it's actually within your purposes. And I think probably you can pretty much assume that it would be here, but it won't always be. So it's certainly, that's kind of the first place to start. And then thinking about, I guess, once you've worked out whether it's something that's feasible in terms of the acceptance, and it's thinking about the funding of that on an ongoing basis. So as Kirsty said, having a chat with Andrew, and thinking about the bigger picture. Is it something that you want to be bringing in? And understanding the asset. So if you were buying something, the Charity Commission would expect you to get a report so that you know what you're getting. And I think you'd probably take the same approach with a gift as well. It's important to know what you're getting. Even if you're not actually paying money for it, you still need to understand that properly.
Yeah, and the rules on acquisition of land by charity are more relaxed. but you still have to go through the same process in terms of best interest test. And I think you're right, you would generally get a report, wouldn't you? You wouldn't just buy something without a report of an estate agent. So, I mean, to my mind, the main thing I would be thinking about here as a trustee is it looks like a really risky opportunity, doesn't it? What could we do as a board of trustees to try and reduce the risk? So we decided we're going to take it, but actually this could become a huge liability on our balance sheets. It could drain our resources very quickly. So what would we think about?
I think you'd probably think about setting up some kind of subsidiary or standalone organisation that would take on that asset and then take on those kind of development opportunities. Because I guess the other thing to come along in terms of thinking about the financial resource in terms of developing it, you also think about the human resource. It would take quite a lot of effort to bring in the funds. It would take a lot of effort in order to manage such a big project. And so there's the kind of employee-related or volunteer-related costs that would come along with that as well. So I think if you were to put it into a separate entity, I guess you'd have to think about whether you really need that entity to be charitable in its own right. Probably a funder's not going to want to give it to a non-charitable entity, albeit a trading subsidiary of a charity. So then you have to think about the kind of the registration element of that and things. But yeah, so I think kind of hiving off that risk probably into a charitable entity would be the way to do it.
And then you need to think about the arrangements, don't you, moving forward between the two. And presumably you would want a formal agreement or documentation with regard to the gift and the terms in which you're taking it on, etc.
And again, trustee resolutions about why it's in the best interest of the charity to be doing it in whichever way you're doing it.
Yeah. And also I was just thinking in terms of funding, I mean likely probably if you're getting heritage lottery funding or equivalent, that is always restricted because it's for the purpose which you apply for it. But if you're going out to sort of major donors, Andrew, you could probably ask to have a bit more flexibility because there's always the question, isn't there, if you raise more money than you need, what a lovely position to be in. That is actually what we would call a failed fundraising appeal, in that you've got too much money and it generally has to be returned. So again, thinking about the conversations with your donors about having some flexibility. So we look beyond the gift. We complete the redevelopment and we've realised actually, do you know what, we don't need to use it all the time, but we could lease it to another organisation. So if that organisation was a charitable dance school, what would the trustees need to think about there?
Again, it's an asset, and so you can either think of that as being an investment asset, which is there for income generation, or a charitable asset. And if we're thinking about leasing to another charity, presumably in furtherance of our charitable purposes, you then think about the extent to which you want some funding back from that, some income back from that. If it was within the charitable purposes and you're not proposing to treat it as an investment asset, you want it to be a way in which you're furthering your charitable purposes, albeit through letting another entity use the site, then you don't have to go through the designated advisor's report. It's part of your charitable activities. And so it's easier to do in that sense. But that doesn't mean that you don't need to have the formal arrangements in place and have made sure that, again, from a reputational perspective, you want that charity to be there. You're working together in a way. So there's all some things to think about. But from a kind of property perspective, it's easier.
Yeah. So the key point there is, are you treating this as an investment asset, in which case your duty is to maximise the return? So generally we're talking about market rents. Yeah. Or can you argue that it's in furtherance of your purposes and therefore you could potentially rent it to a dance school on less than market rent, but only if it's furthering your purposes. So it's understanding how you're again going to treat it moving forwards. Okay, so I think that is it in terms of our case studies. We'll come on to questions, but I'm just going to touch on one last thing and then we will open up the floor to any questions that are not employment law related, and then, or we can just break for lunch. So I'm just going to touch on the very last bit because it would be prudent for me to mention this wonderful piece of legislation. You're going to look at me and go, why on earth is this relevant to me? So the Economic Crime and Corporate Transparency Act of 2023, is relevant to you, and the aim of it is to prevent abuse of UK corporate structures and tackle economic crime. What's changing and what is relevant to you as charities? Well, really, it's relevant if you are a charitable company. So if anybody in this room is a trustee of a charitable company, then the ECCTA, it's nice and catchy, applies to you. So we've got a new offence, the failure to prevent fraud, and I'll come on to that. We have to verify ID for directors, that's the trustees, I'll come on to that. Greater powers for Companies House, including higher filing fees and penalties. Stricter registered office rules, so if you're a charitable company, you can no longer have a PO box as your registered office, you have to have a physical office. Digitisation of the register, everything is going to be dealt with online, so if you're not set up for that. And increased financial disclosure. Unfortunately, they're getting rid of the rules which allow you to file abridged accounts. So the aim of this, as I say, is to tackle economic crime, and charitable companies will be caught by this. So the new failure to prevent fraud offence, it came in on the 1st of September. So it probably doesn't apply to anyone in this room. You have to have more than 250 employees, 36 million of income, or 18 million in total assets. It's at least two of the following. So I suspect it doesn't, but it's just really to flag it. And unfortunately, what it means is that the organisation can be criminally liable if an employee or anybody associated with it commits a fraud intending to benefit the organisation and you didn't have reasonable fraud prevention procedures in place. And there's no requirement to demonstrate that the directors or senior managers ordered or even knew about the fraud. Just generally, I think, review your fraud procedures, even if this doesn't fall within your remit, because actually fraud is a huge risk to charities. We've talked about it, but it is a risk. So that's probably not relevant. Seek professional advice. I would direct you anyway to the Charity Commission Guidance Internal Financial Controls if you haven't read it, but there is some specific advice from the Charity Commission on protecting your charity from fraud, which is really useful. But the bit which is relevant for you if you are a charitable company is the new identification verification process, IVP. So from the 18th of November, IVP becomes compulsory as part of incorporation, so you cannot incorporate a new company unless all directors and persons with significant control have been verified via Companies House. And it's compulsory for anybody that you appoint as a director and trustee from the 18th of November. It's dealt with online. I've done it. It's relatively straightforward, but you need to be organised on that. If you are an existing director of a charitable company, we've got a transitional period to complete this, and that is from the 18th of November until your next confirmation statement is filed, so your old style annual return. So it's basically until autumn next year. So if you're a charitable company, you need to think about going through the IVP process for your directors. So all I'd say is try and get it done as soon as possible. It is online, it is relatively straightforward. You have to set up a unique account for an individual director. You might want to get them in to do it. Include it in your trustee recruitment process because you'll have to get it done. And it will be an offence, just so everybody understands, and obviously it's an offence Companies House and not offences we take lightly, if you act as a director and you haven't verified your ID, and it will be an offence for the charity to be directed, i.e. controlled by an unverified director. And I suspect if either of those happened, you would have to go to the Commission and report it as a serious incident report. Okay? And they will have the ability to take action for failure to comply. So that's just a flag, really. I'm just going to flag this really because it's also a potential opportunity, because the thing about charitable companies is they were always a brilliant vehicle for charities that wanted to have the protection of limited liability and have legal personality pre-2006 when the charitable incorporated organisations came in. Although it took 10 years for us to actually be able to set them up, you can potentially think of this as an opportunity. Because I think what it does mean, particularly for smaller charities that are currently set up as charitable companies, is it will increase your administrative load quite considerably. Your annual filings are going to become much more complicated, more costly, because the filing fees are going up considerably. You'll need to do ID checks. It's not always that easy. Some people don't always have the ID that they need, and there are risks of quite substantial penalties. The reason I'm saying this is because if you are a CIO, you are not subject to ECCTA IVP. So that means that there might be an opportunity for you, if you are a charitable company, to convert to a CIO. And it is possible. It's possible under the legislation, and we'd be happy if anyone wants to talk it through to advise on that process. So I think for any of you that are smaller charitable companies, it might be a prudent time to think about whether or not you want to convert.